broadcast. Let's continue the meeting. Please invite Retynska Yuliia Ihorivna.
Доброго дня. Розглядається питання
Good
щодо
afternoon.
відповідності
We will consider the compliance of the candidate Retynska with the criteria provided for by the Article 80 of the Law on Higher Anti-Corruption Court. In this hall, there are Robert Heisen, Gabriela Yotkait, Mary Butler, Line, Gabriela online, and Jessica Thompson, members of the QCJ of Ukraine, Igor Kusnir, Ruslan Melnik, Alexei Domilyan, Pasechnik, Roman Sapadash, Ruslan Sidorovich, Sergei Chumak, Lana Shevchuk, and others. You have a right to recuse the members of the Commission, file motions, and provide explanations, and with the permission of the Chair, express your objections to the questions considered and challenge the decisions according to the procedure provided by the law. Will there be any recusals? No recusals. I am drawing your attention to the fact that in this joint meeting we will not consider any additional materials if the candidates could submit such materials before, but the candidate or other people failed to provide these documents to the PCIe or the Commission if there are circumstances that may affect the decision upon the initiative of the candidate or at least 3 members of PCIe the Commission. The decision may be made to attach additional materials if at least 4 members of the PCIe vote for such a decision. Will there be any motions? No motions at this point. Thank you. The rapporteur will be Melnik Ruslan Ivanovich, please. Thank you.
Retynska Yuliia Ihorivna.
So, Retynska Yuliia Ihorivna in 2006 graduated from Zaporizhia Institute of State and Municipal Administration and got a higher education with the degree Master of Law. As to the professional activity, starting from 2002 till 2004, she worked as a secretary during court hearings of the Appellate Court of Zaporizhia region. From 2002 till 2010, the main specialist in the same court, and from 2010 till 2012, head of the department in the Appellate Court of Zaporizhia region. By the order of the President of Ukraine of April 2012, Yuliia Retynska was appointed at the position of judge of the Zavitsky District Court of Zaporizhia City for 5 years. She took an oath in May 2012 by the order of the President of Ukraine from February 2022. Ms. Retynska was appointed to the position of the judge of Zavitsky District Court of the city of Zaporizhia for an unlimited term by the decision of the Commission of January 2024. The judge Retynska Yuliia Ihorivna is recognized as one corresponding to the occupied position. I should also note that in 2012 the candidate was a delegate at the 15th assembly, the 15th meeting of judges of Ukraine. She was not selected to the judicial self-government bodies, High Qualification Commission of Judges of Ukraine, High Council of Justice, High Council of
Це доповідь базова інформація.
Justice. Thank you. That's the basic expose. Would you like to add something? No, nothing to add. Everything is right. All right, so the floor is yours, Mr. Robert.
Thank you, Mr. Chair. I pass the floor to the rapporteur, Mary. She's on the screen.
Thank you. So my name is Mary Butler, and I'm a prosecutor in the United States. I've specialized in anti-corruption work for most of my career. I want to thank you for your cooperation in this important process. I understand that you have answered many questions of ours in writing before appearing here today. Some of my questions will ask you to repeat in this public hearing some of the information you provided. We're doing that for the importance of the public's awareness of this process. So first, we have heard and we know your background is as a judge of the Zawodzki District Court in Zaporizhia, and prior to that in the Appellate Court of Zaporizhia. Please tell us why you have applied to work for the Hague Court.
Відповідаючи на дане запитання,
To answer your question, I would like to say that indeed for me it means a career growth, because for 13 years I've been occupying the position of a judge of a local court, and I would like to participate in the work of the High Anti-Corruption Court. Maybe I will discover something new for myself. I will acquire new knowledge, but I will absolutely be able to share and apply the knowledge I acquired before over the years of my work. That's probably the main motivation why I would like to become the Hague judge. Thank you.
Is there anything about the types of cases which the Hague considers that you're especially interested in?
ну так, звичайно, це
Yes, of course. These are all interesting cases. They are at the same time complicated because there is a big public interest as the cases are considered in relation to public officials, and the specialization is narrower, and I can pay attention to those specific matters. And as I already said, the specialization is just narrow, and I can focus on those specific matters. It will be easier in this sense, I mean.
In your capacity as a district court judge, do you handle criminal and civil cases?
Так, у нас в суді абсолютно немає.
Yes, in our court, the judges do not have any specialization, so I consider both criminal proceedings and civil ones. Also, the cases involving administrative offenses, and I am the investigative judge and the juvenile judge.
And can you tell us about how much of your docket has involved criminal cases?
Та, мабуть, наполовину.
Maybe 50%, maybe one half. No, sorry.
Цивільних справ дійсно більше.
We have more civil cases,
Все ж таки 30 є кримінальні
but
справи.
probably 30% of them are criminal cases.
And have any of those criminal cases or administrative cases involved allegations of violations of corruption laws.
Єдина справа, яку я
The
розглядала
only case I considered that was
за статтею 191
under Article 191, Part 5, was the one I considered just recently, and currently this case is reviewed by the Court of Appeal. As I mentioned, it's not the case that can be called a huge gain. Actually, the accused party acknowledged the guilt, so even though we considered the case, the defense party didn't emphasize any drawbacks during the pre-trial investigation. They acknowledged the guilt, and so I considered the case.
And so, just so I'm clear, are you saying that this is the only case that you've handled that involves violations of the corruption laws of Ukraine? Or it's just a recent one?
Так, це єдина.
Yeah, the only case.
Саме кримінальна єдина справа і
Criminal case
справа про адмінправопорушення, це
a case of
недекларування,
on administrative offenses,
її я так само
failure to declare on time, and that was a recent case. I don't even know whether there are still whether it still can be challenged.
So let me ask you some questions about your experience applying the criminal procedure rules. So if I understand you, you said this most recent case involved a guilty plea agreement. Is that right?
Так, все вірно.
Yes, exactly.
And have you considered many cases with guilty plea agreements?
Так, багато.
Yes, there were many cases like this. It is a common practice to consider cases under Article 349 of the Criminal Procedural Code, where the party pleads guilty, and the court, after clarifying the position of all the parties, whether this guilty plea can be accepted, that is accepted without witnesses' hearings, without written evidences consideration, written proof consideration. Maybe about a third of my cases are like that.
Thank you. And you said that you served as an investigating judge. When you're in that position, is that your whole assignment for a period of time?
З самого початку, от як були зміни
Since the beginning,
у 2012 році,
in 2012, a new criminal procedural code was adopted,
да, така стаття, така
and there was an article related to investigating judges, and by the panel of judges, 6 judges were elected to be investigating judges, and until now I have dealt with such cases.
So you're actually an investigating judge in the district court? Or that has been one of you are an investigating judge?
Це вірно.
Yes, this is correct.
So do you preside over trials? Have you presided over trials in your time on the district court?
Ну, у нас здебільшого в районних судах справи розглядаються
Well, in
суддею
district
одного
courts,
судового. Це
cases are considered by the judge
коли
only,
стаття
and
передбачає,
sometimes there are exceptions when the article has provisions
позбавлення волі, особливо
for life-long imprisonment for grave heinous crimes. Then such cases are considered with a panel of judges, and if a case does not involve lifelong imprisonment and a criminal offense is a grave one, the suspect can make a motion to have a case heard by a panel of judges, and in some cases I might preside the trial, or I could be one of the judges in the panel of judges. So I've had cases like this.
So approximately how many trials have you participated in the resolution of in your almost 14 years on the district court?
Ви маєте на увазі в складі
Are you talking
колегії?
about when I was a part of a panel of judges or in general?
In any capacity. Presiding over trials as opposed to accepting guilty plea agreements.
Я зрозуміла. Ну, я
Okay, this is clear.
перепитувала у
So I clarified that yesterday, approached our head of apparatus regarding this, regarding the number of cases I considered for the whole period, around 8,100 cases. And regarding cases where the cases are considered by a panel of judges, maybe 10 cases. But to be honest, I did not get prepared for such a question. I cannot give you an exact number. Mostly it was about willful killings, part 2 with aggravating circumstances, and also cases related to treason.
Thank you. I understand that you served as a spokesperson for the district court. Can you explain your duties as a spokesperson for the court?
Ви маєте на увазі суддя спікер, да? Я так розумію.
You mean judge spokesperson?
It's my
Is that what you mean?
Так. Це було нетривало, тому що саме
it didn't last long when I didn't have capacity. I was elected judge spokesperson.
Мої повноваження особливо, ну, скажімо так,
And as to my powers as spokesperson, I would provide information to some officials who were connected to the mass media in certain cases, and then based on that, in those cases that were interesting to the mass media, we would disclose some information to make it public on behalf of our court. And that also included managing the court's website. That is it.
Thank you. I see that there are approximately 11 cases of administrative offenses under Article 130 of the Code of Administrative Offenses that were closed due to the expiration of the times for bringing a person to liability. Can you explain what explains why those cases had to be dismissed? Not with the details of each case, but in general, your approach, why you didn't hold hearings to try people in absentia, for example.
Я зрозуміла.
Okay, the question is clear. So here we need to talk about different periods separately. 2016, and then after my capacity was resumed in 2022, there were modifications in the law. 2016, in 2016, only 3 months was the deadline to be held liable in administrative offenses. And as I reviewed those cases, about 90% of those arrived to my consideration after those deadlines were overdue, or at least a couple of days were left, and I wasn't able to summon a party, and we usually summon the parties to the dispute by physical mail, and not always the parties provide their contact data, and the only way we could summon them is to send it by mail. And it is clear that not always the court could receive a confirmation that the individual had actually received was summoned and received the notification.
So your understanding is that the reason that these cases had to be dismissed had to do with notice to the person, not for some other reason. Is that correct?
Ще раз, я повторю, дивіться.
Yeah, I will say it again. So most cases, more than half of the cases, made it to my office with the statutory limits overdue. And therefore, I couldn't talk about any other stages because the deadline was overdue. At other occasions, those cases only contained a few days for the court to be able to process the case, and the parties did not show up to the court after we've sent them a notice, or they have not received our notice. There was no sense in us continuing to notice them because the statutory limitations were overdue.
Now I want to ask you a question about your use of the Unified Register of Judicial Decisions. We asked you some questions about your use of that registry, and you responded that you use full access to the registry mostly for purposes related to your professional activities as a judge. You further said, I assume that sometimes the access was not related to my professional activities as a judge. Please tell us under what circumstances would you use the non-public unified registry unrelated to your professional activity as a judge? Can you clarify that for us?
Так, дякую. Я написала
Yes, thank you. So I started my explanation like this because at that time I couldn't respond to those questions quickly, and I said that I reserve the right to use the register, the full access to the register, beyond my professional need. And after I analyzed these questions, and after I got familiarized with the dossier, my dossier, I acknowledge that I made use my full access to the register in different cases, because sometimes it's far more practical to check a certain case without studying the data about the parties before. So in such cases, I would use my full access to the register. And I could and when I would logged in the register, I could choose between the full access and limited access. And mostly, indeed, I use the register only to perform my duties. Can I continue?
Sure.
Так. Зараз. І що я хотіла сказати? Я хотіла сказати
what I wanted to say is the following. When we were granted the full access, we were warned of the fact that we could not share our credentials, passwords, logins, and we could not publicize the information that became known to us. So there was no violations on my part with regards to the information that became known to me, and I did not disclose it to anyone, and I did not share my credentials to anyone.
And can you confirm that you didn't use the register to search for the names of family or friends, just for the cases to which you were assigned?
So,
in fact, I checked information regarding my family members, but I don't remember the context, the reasons why I did it. So I just checked this information yesterday. I checked my answers yesterday. And then regarding my friends, there was one case which I recall. A friend of mine turned to me to have me help her. She was divorced, and there was information known to her that her ex-husband was held criminally liable. And that information could be obtained either through the website of the judicial power, or which was easier, quicker to use the state register, and therefore she turned to me because I had access to it. And that case was not considered in the closed format. There was no violations of the secret of pre-trial. There was none of it. There were no searches in that case, and there was no information regarding that man.
Thank you. And now a couple of questions brought to our attention by civil society organizations. First, do you confirm that you have not disclosed receiving any alimony or child support for your daughter because you haven't received any?
This is correct. I confirm it. I didn't live with my child's father. We did not share household, and I did not receive alimony.
Thank you. In your asset declarations for 2015 to 2017, you declared an apartment with total area of 59.21 square meters, acquired on November 6th, 1997. Did you live in this apartment with your mother and daughter during this time?
Yes,
this is the only real estate object that is that I own, and that is used by my mother and my daughter from the moment we registered that apartment in 1995, and my mother and myself have lived there since 1995. My daughter lived there since she was born, and no other real estate objects are owned by us.
Thank you. So my question is, why did you not disclose their rights to the use of the apartment before 2018? I think 2018 is the first year in which you reference their rights to that property. Was it a mistake, or was that an interpretation by you of the rules?
Yes, indeed. And I will now share information that I had in December 2018. I found explanations on the Agency for Corruption Prevention website on the subject. Before 2018, everyone had a lot of questions regarding, well, in fact, I didn't even doubt that I was filling out my declaration appropriately. After the National Agency for Corruption Prevention in December 2018, I realized I had made a mistake, and in my declaration in 2019, my declaration for 2018, I started declaring my mother's and my daughter's right to use the apartment. At the same time, I indicated in all of my declarations that they are my family members. I indicated my mother's income, and one could draw a conclusion that they were living in that apartment, that they were using the apartment. So for me, that was the following. I indicated my ownership right to that only real estate object. And because I indicated these people as my family members, it seemed logical to me that they would be entitled to use that apartment too. And no other real estate object is not owned is owned by me.
And just two more questions. One is about your declaration in 2017 that you had cash in the amount of approximately 4,000 US dollars, which was disclosed as approximately 119,000 hryvnia. This appears to be about half of your annual income declared in 2017. But in 2016, you did not declare any cash assets. Can you explain to us what the source of the 119,000 hryvnia was that you declared in 2017?
Відповідаючи на дане запитання, хочу
To
зазначити,
respond your respond to your questions, I had assets in 2016 too. I had savings, but because the threshold for the sum was 68, the threshold of the sum that may not be declared, and I had 68,000 hryvnias as savings. I did not declare it, and then the following year I declared the whole sum. But those savings were not made in 1 year, for sure not. And as to the sources of income, is my judge's salary. I have no other sources of income.
And then the last question has to do with a Ford Fiesta, a 2017 model. In your 2020 declaration, you declared that you acquired this car for 191,623 hryvnia. But in 2025, cars of this brand, make, and year were offered for sale in public sources for approximately 338,000 hryvnia. And my questions are, number one, can you tell us what funds you used to buy the car? And number two, can you explain why the value you reported seems to be lower than the market price for the car at that time?
Відповідаючи на перше запитання щодо джерела доходів.
Answering your first question regarding my source of income, it is only my judge's remuneration. And in declaration for 2019, I declared cash 9,000 US dollars. So I could afford to buy that vehicle at the stated price. And regarding the value of the vehicle, the prices at that time were approximately the same as now. And second thing, that vehicle, and I actually saw that concerns raised by the CSOs, my car has mechanical transmission rather than automatic, and mechanical transmission cars tend to cost less. And from the very beginning, that car had some damage sustained. That was a car brought from the United States of America to Ukraine. And just like Today, back then, prices for cars imported from abroad and bought at purchased at bids, they cost cheaper, and that car was bought at a service center, Mario, and the evaluation was made, and it was in line with the price stated by us in the purchase and sale agreement. This is the first thing. And in order to provide the proof, I turned to the Mario service center, and I got an answer that because it was 5 years ago, they couldn't provide me an evaluation of the price. And I have no other proof to show that the evaluation is in line with the sum stated in the contract. What can I add to this? Even after the repairs that were done, it was insignificant repairs, just slight repairs. There were some scratches. They are still there. So some shortcomings were there at the moment of the purchase, and I was aware of them, and they stayed. And this is why we decided to make a deal at such a price. And one more point about the bids. The car was brought from the US, and I also agreed that I would also pay for registering the car in Ukraine, and the seller had let me know that in advance, and I knew that I would need to register the car in Ukraine for at my own expense. And so I was responsible for the rest of the expenses after the car was brought to Ukraine.
I wanted to add that there was no reason for me to say something false from the point of view of the price, because it couldn't affect the taxes. It was a real price that I paid to the vehicle for the vehicle, and that's what was offered by the sellers.
Thank you. I have no further questions.
Thank you, Mary. Anyone further questions? Gabrielle? No. No? No, thank you. Back to you, Mr. Chair.
Дякую, пане Руслане.
Thank you, Ruslan.
Дякую.
Thank you. Well, thanks to the colleagues from the Public Council of International Experts, we've basically clarified all the questions raised by the CSOs, and we've addressed the doubts that arose in relation to your file and your declarations about the assets that you declare. Starting from a certain point in time, you started accumulating assets, starting from 2017, 4.5, then 9, then 15, and so the assets keep growing. The only non-typical period, as it may seem, was the period when in 2020 you buy the movable property, the vehicle. That year, you managed to accumulate the biggest amount of savings. So you had 9 from the previous period, you spent 7, and 15 remain. So comparing to other periods, it looks non-typical. What was it a special year because the income was more or less stable? Yes, of course, it can be explained. About the income, it's not like you said, because for 2019, I was trying to make a table for myself with the income I had. So I had 399,000 hryvnias approximately, and and in 2020, approximately 789,000. So in 2020, my income increased significantly, and it was related to the changes of the Constitutional Court. Yeah, I understand you compare it to the previous year, but if we compare 2020 to 2021, what was the increase?
Десь на 7 получається, да?
Да, десь на 7 так
На
і-
7.
да, да, да.
7 approximately, right? And during the previous period, like 2 remained after the purchase of the vehicle, then 13 were saved. It's something which can cause doubts during the change of the lifestyle in that period. Maybe you accumulated more. I understand that at least according to the registers, you didn't spend money for trips or vacations, so there were no expenses like that. Yes, that's true. And based on the declaration and the information from the registers, you have quite a modest lifestyle. And basically, that's it. I have expired my additional questions related to your financial integrity, as we call it. And I have another question related to knowledge and skills in the area of anti-corruption activities. As I was studying the information you provided in the questionnaire, I noticed that you write that the hack was established to fight corruption. Can tell us, please, whether it's one of the functions of the hack to fight corruption? No, administering justice. It's the function, it's the objective of the High Anti-Corruption Court, timely consideration of cases, and one that would allow no doubts as to impartiality, no judges. So the purpose is only administering justice when it comes to certain categories of cases. And who is fighting corruption? What bodies? NABU, SAPO, law enforcement. Thank you. And another logical question: what is corruption? Corruption is, first of all, an abuse by an individual who has certain functions of state authorities, self-government, abuse of its functions to get unlawful benefits or to incite to get unlawful benefits, but also provision to certain people of such illegal benefits to resolve some issues. You mean benefits for this individual or third parties? Yes. Tell us, please, whether it's one of the sanctions of hack to consider administrative offenses related to corruption. So, for example, we have administrative offenses related to corruption as provided by the Code of Administrative Offense. The High Anti-Corruption Court works on cases related to sanctions, obviously, but the question was about administrative offenses related to corruption. No, as far as I remember. Yes, thank you. No other questions from me. Roman, please. Good afternoon. I have a few questions to you. One of them is related to your vacations and days off. There is a period in 2025, for example, from the 11th of March till the 12th of March, you are on vacation. Due to the from the 14th of March then till 18th of March, you are on sick leave. Then from the 11th of March till 21st of March, another vacation, and the 24th of March till 2nd of April, another vacation. So basically, 1 month you were not allocated cases. That's according to the data on allocation of cases. Yes, it's true that there was such a situation. The schedule of vacations is made in December, and I always take this vacation during the vacation of the child. Yes, it's not about this period, it's about the sick leave that was just between these two short periods of vacation. It was last year, so it was first a short period of vacation, then a period of sick leave, and then again the period of vacation. So I didn't see the allocation of cases made over that whole period. That's a coincidence. Over the whole period of my work, I only took the days off due to the sickness twice. And the same happened in July, on the 14th of July till 16th. You were not allocated on the 16th till the 18th. There was a business trip, then another short period when there was no allocation, and then a vacation till the 9th. Like the whole August, also the period of summer holidays, you had a business trip there, 2 days. So it was somehow, it somehow coincided with the vacation and lack of allocation. Well, maybe back then it was 14 days. Well, it was a coincidence. I wouldn't be able to start working on the cases in any case. Okay, it's clear. Another question. You were already asked about the automatic allocation today. You search people using this automatic allocation, and you kept searching the same person over the years, even though you had only case with that specific people, with that specific person? I cannot recall that case. The name was Vasil. There are several searchers from 2017, but you got the case in 2019. I do not recall that. All right, thank you. Ms. Yulia, good afternoon once again. I will have a few questions. First, I can see you left Ukraine. You went abroad in 2023. What was the purpose? There was a training and there was a business trip. Thank you. It's clear. Another question. When the full-scale war started, all the judges As I can imagine, all the judges were writing applications
Я навіть градацію знаю, хто як писав, скільки Верховний суд
to transfer some funds to the institutions involved in the defense of Ukraine. Did you write such a request? No, I didn't. We have the joint groups with other judges, and specific colleagues were asking for help, financial help. As I knew those people personally, I would transfer the funds. No accusations here. It's not about it. Can you tell us how much was it in 2022, 2023? It's hard to recall. There were different sums depending on the needs people were collecting for. Sometimes it was 1,000 hryvnias, sometimes 500. All right, it's clear. I will have a bit contradictory question. We all know how hard it is allegedly for the judges of first instances, because the salaries are low, the workload is huge. The MPs are very worried how to increase your salaries because 60, 70,000 hryvnias is not a lot in our current conditions when there is inflation and the change of exchange rates, etc. At the same time, you basically refute it by your lifestyle. Over the years, you show that it's not true that the first instance judges require some additional increase of salaries. For instance, you accumulate $15,000. It's my personal opinion. Maybe it will not be supported, but someone who accumulated $16,000 a year, what kind of insufficient funding of judges of first instances can we talk about if a judge over the first instance can accumulate $16,000? And it's not a unique year, because over the 4 years of war, you accumulated $45,000. Well, it's on average more than $10,000 a year. The whole country is so worried that the judges of the first instance have to survive. But you actually refute all of that. You dispel all the worries of the members of the parliament and our worries in particular. Can you comment on that? Some judges state that the funding is insufficient for the first instance, but actually we can see such savings. That's my personal opinion. Maybe you can object and say that it's wrong and the life is really difficult for the judges of first instance. Thank you. I have certain priorities in my life, and I have been accumulating this money for the housing. I have such a dream because my mother gave me an apartment as a present, and we live with my mother and my daughter. So I have a dream to buy my own housing. That's the first thing. Secondly, about the year 2022, unfortunately, the full-scale war started on that year, and back then I didn't want anything. Not the trips, even short-term ones, not going to restaurants or cafes. I wanted nothing. So if we look at the 2022, I indicated $10,000. At the same time, there was cash on my bank account. It was approximately $8,000. so that sum as of 31st of December 2022 was later converted into dollars, and that's how I got that significant increase over 2 years. And later, the situation stabilized. No, it didn't stabilize, but it was hard to live in that mode. Also, I have a child, and I have to distract her from the war. All right, thank you. It's logical and it's understandable that if you dream about housing, you need to accumulate money and show that you have money to later purchase it. Thank you for your explanation. Thank you for answering. Thank you, colleagues. To manifest solidarity, I would like to say that the hack judges never wrote any requests to transfer funds, but to do it regularly to private individuals. All right. We even supply certain items to the front line and even to the zero line. I have a different question. It's about your professional skills to work at the hack. Tell us, please, on what grounds can the special pre-trial investigation be conducted? There is the article of the Criminal Procedure Code. Unfortunately, I do not recall the number of that article, but based on that article, okay, what's the grounds to initiate a special pretrial investigation? When the person was at the temporarily occupied territory, I will clarify what kind of procedural document. The procedural document on the state? No. On what procedural document? The court ruling? Court, we discussed during the preparatory meeting. I'm talking about the special pre-trial investigation. Oh, yes, sorry. Also the ruling, but of this investigative judge. Okay, it's clear. And another practical question. You know that the defense attorney uses the rights of the accused or suspected person. You are a judge and the defense attorney explains what are the evidence, but it's not in Ukrainian language. And the defense attorney wants it to be translated for the defense party. What are your actions? It is provided for by the law. We involve translators in proceedings when there are documents that either defense party or the accused do not understand. So you will use translation services for the defense attorney. I will ask whether the accused understands this situation. I think first it's necessary to understand whether the defense attorney has this right. Maybe I didn't understand the question. If the documents are already in the materials of the criminal case in the court, well, they have to be translated for the court too. Well, that's right, but the motion came from the defense counsel to involve a translator for him for the cost of the state budget. It's not about the materials that you have to work on as a court. I'm talking about a different case. Well, I've never had such situations, but you are a candidate to the hack. Believe me, there are many different cases. In any case, if a party provides an evidence, this party has to provide this document to the court with translation for it to be clearer for the court. I understand your position. Thank you for the answer. Good afternoon, Yulia, Ruslan Sidorovich. A very brief question on your statistics. Tell us, please, in 2024, the number of civil cases that you do not consider on time grew significantly. If we compare it to 2023, the number grew significantly. No questions about criminal cases. You consider everything on time, nothing to say about it, but the number of unconsidered civil cases grew threefold. Could you explain us what happened to your personal circumstances? Yes, of course, I can explain. Over that period, starting from 2023, the number of cases that we had to consider in absentia grew significantly. I'm talking about civil cases. Yes. If before that we didn't have this category of cases, and these categories require much more time for consideration because they are all considered with complete analysis of evidence. So I spent more time considering criminal cases, and I used the rest of my time to consider civil cases. That's how it happened that at the expense of certain civil cases, I could consider more cases in absentia. A clarifying question for us to understand correctly. It's not an increase in number, because if we look at the number, it's the same. The category changed. Okay, the category changed. Thank you. Now, the questions, the esteemed members of PCIE, any other questions from you? Mr. Robert, no questions?
I don't think so, Mr. Chair. So back to you.
Добре. Дякую. Так, оскільки відповіді ми всі одержали.
All right, thank you. We have our answers. Ms. Yuliia, please, you have a chance to add something, clarify something if necessary. Thank you. I have nothing to add. We've discussed all the matters. I hope that if there were any doubts, I managed to dispel them, and I was answering honestly. I would like to thank the members of the High Qualification Commission of Judges and the Public Council of International Experts for this competition, for the involvement. Just thank you. That's it. All right. Thank you for your participants in the interview.